So I'm listed as an affiliate of LAG because I'm helping work on the matter, but the legal information I'm giving today, disclaimer of course, is just being given by me as a private individual. So it's just trying to be a little bit of an information, not official legal. So, in Australia, in August last year, the Lesbian Action Group made a booking request at the Victorian purpose-built, government-funded Pride Centre to hold a female-only, lesbian-only event for International Lesbian Day. To support this booking and to give it a legal base from which to rightfully exclude any men trying to attend, it also applied to the Australian Human Rights Commission, the AHRC, for an exemption from federal discrimination law on the basis of sex and sexual orientation. This would give it a defence if anyone challenged the female lesbian-only entry policy. The Pride Centre refused the booking. It said that permitting a female-only, lesbian-only event was inconsistent with its purpose of inclusion and its constitution. The AHRC then refused the application. The Commission agreed that lesbians in Australia have faced significant structural and entrenched discrimination, and that it is important for lesbians to gather together as a community. But that transgender women can be women within the meaning of the Sex Discrimination Act, and that it is not appropriate and reasonable to make distinctions between women based on their biological sex at birth or their transgender experience. In other words, just a couple of choice comments that were posted in response to submissions for the Lesbian Action Group. Good luck, fascist. Victorians see straight through your transphobic, segregationist rubbish. If you did get the exemption, you won't. We'd ruin your event with a protest. 96% of lesbians are fully supportive of trans women and include them within lesbian. You're a weirdo extremist. Typical bigot pretending transgender women are men. I cried a lot. It was very upsetting. So, in other words, the Commission agreed that an exemption on the grounds of sexual orientation was appropriate because of the disadvantage suffered by lesbians. The Commission also agreed that an exemption on the basis of sex was appropriate and that women will sometimes be justified in excluding men. But the Commission disagreed that transgender women, I'm going to get tired of doing this, so can we just that transgender women were men. They found that the category of legal women, women for the purposes of law, included both biological women and transgender women, and that separating one from the other constituted a third kind of discrimination, discrimination on the basis of gender identity. And the Commission did not find that it was appropriate to do this. By way of comparison, in August last year, the AHRC, so at the same time, granted an exemption to Save the Children to allow them to lawfully discriminate on the basis of sex when hiring telephone counsellors for its mostly female callers, victims of domestic and sexual violence from mostly male perpetrators. The Save the Children application said that hearing a male voice answer a call or hearing a male voice answer and identify their name, for example, can potentially trigger a response as the person using violence may have had the same name as the person answering the call. So, why did the AHRC grant a sex-based exemption to Save the Children but refuse one to LAG? Because Save the Children defined sex in its application as female identifying. Only one public submission was received in this application, compared with 498 total submissions in the LAG application. This submission was from the Victorian Equal Opportunity and Human Rights Commission, and it said, "It is positive that the applicant is seeking to provide exemption for workers who identify as females, as this affirms gender identity in the applicant's recruitment practice. As if a child calling for counselling would care what the identification was when they heard the male voice on the telephone." So in late 2023, LAG filed an appeal against the Commission's determination to be heard at the Administrative Appeals Tribunal starting April this year. From there, further appeals are available to the federal courts. A tribunal cannot change the law. It can only interpret it or apply it differently if it is not already bound by a higher authority. So what is the law in the area? Discrimination on the basis of sex and sexual orientation is governed in Victoria by both federal law, the Sex Discrimination Act, and state law, the Equal Opportunity Act. This is the same basically in other states and territories. These laws overlap and in many cases say exactly the same thing. Each law has its own Human Rights Commission administering it and taking complaints, the AHRC for the SDA, I'm sorry for initialisms, and VORC for the EOA. An exemption from the SDA has to be requested from the AHRC, while an exemption from the EOA has to be requested from VORC. It is a matter of internal policy whether the commissions make the same decision. According to the letter of the law, you could get an exemption from one but be refused by the other. You would then be protected from complaints under the first law but not under the second. A complaint can be made to either commission or to both against you. As a matter of internal policy, VORC would reject a complaint that was already lodged with the AHRC, but it is discretionary. The SDA says that the AHRC must reject a complaint that's already filed with VORC, so the state law does take minor precedence. Appeals from decisions of these commissions go up to the relevant tribunal, the Administrative Appeals Tribunal for the AHRC and VCAT for VORC decisions. Appeals from the decisions of these tribunals then go up to the relevant court, the Federal Court for AAT rulings and the Supreme Court for VCAT rulings. Ultimately, multiple appeals from either could eventually reach the High Court, and that's where state and federal jurisdictions meet. Costs increase at each level. Time, complexity of legal argument, strictness of evidence all increase too. But so does the power of the body to make a decision that alters the meaning of the law or changes the application of it to the facts. So what is the meaning of the law? Discrimination is unfavourable treatment or the imposition of a disadvantage in a way that the law thinks is not justified. Now, discrimination is not always unlawful. It must, for instance, be done on the basis of one of the protected attributes or grounds, and it must be done in one of the protected places, such as employment, education, or the provision of goods and services. Sex and sexual orientation are both listed as protected attributes in the SDA and the EOA, so this is not the problem. The problem is how they are defined. Currently, sex is being interpreted and applied by both federal and Victorian commissions as legal sex rather than as biological sex. Just a note on legal sex. Legal sex in Australia is not defined. It is not determined by one document, including your birth certificate, and it is not exactly the same as self-ID, which is a British term that applies better in a country with one parliament and one official database that records sex. Australia has 9 parliaments, and laws that interact with sex can all use different definitions. For example, sex for the purposes of marriage has been since 2003, based on the balance of appearance, chromosomes, legal documents, name, pronouns, brain sex, personal identity, etc. But this was not the same definition under the law for changing sex on your passport. Nowadays, most Australian laws allow self-identification of gender/sex based on an internal self-identity, perhaps supported by 2 stat decks, you and 1 medical professional. But you do have to check for each law that you are talking about. So, the categories within legal sex go something like this. Category 1, cis women. Everyone is considered to have a gender identity. Your legal sex is woman and your gender identity is cis. 2, trans women. Their legal sex is also women, but their gender identity is trans. 3, other, which may include categories such as queer women, intersex women. The idea that DSDs are sex-specific is not current in Australian jurisprudence, so people with intersex conditions are broadly considered neither women nor men, but may identify as either or neither. Now, Federal law. That requires a comparator to prove discrimination. A comparator is someone to compare the treatment with. Now, this is a difficult point because the essence of tertiary is that the wrong comparator is being used. Trans women are not discriminated against if they are treated differently from a woman because we say the correct comparator would be another man. The essence of the current law, however, is that trans women are discriminated against if they are treated differently from women because the correct comparator is another woman, a cis woman. And that the correct comparator is not another trans woman in itself tells you that they know exactly who the real women are. Under Victorian and ACT law, the test is even easier. No comparator is even needed. A trans woman only needs to show that they were treated unfavourably with no comparison to anyone else. Victorian law is therefore a harder case for us to argue against. So, the law effectively pits subcategories of legal sex against each other. You not only need to show that you have a valid reason for treating men differently. If you want to benefit biological women, you also need to show that you have a valid reason for treating the other subcategories of legal women differently too. If you do not, you are discriminating on the basis of gender identity within the concept of legal sex. The AHRC said in its lag ruling that transgender lesbians also suffer structural and entrenched discrimination, and that granting the application might, quote, lead to the further exclusion of and discrimination against transgender women who are lesbians. They found, on the other hand, no persuasive evidence that actual lesbians were at risk. State law. Federal law. Sex. Sex has never been defined in the SDA. The words woman and man were defined as members of the female sex and members of the male sex, but the meaning of sex was implied, and in 2013 these definitions were removed. Sexual orientation was added in 2013 and defined as attraction to the same sex, a different sex, or both. The word sex here is still undefined. Gender identity was also included in 2013 and defined as the gender-related identity, appearance or mannerisms or other gender-related characteristics of a person, whether by way of medical intervention or not, with or without regard to the person's designated sex at birth. Nowhere in the Act does it say that gender identity determines a person's sex or sexual orientation, but that is not how the AHRC is interpreting it. In the explanatory memorandum for the 2013 changes, the Attorney-General said that the definitions of woman and man were being removed in order to stop them being defined so narrowly as to prevent a, quote, transgender woman from accessing protections for women under the Act. Explanatory memoranda are used by courts for the interpretation of statutes. The AHRC is relying on this statement to justify a reading of all references to sex being inclusive of gender identity and therefore meaning legal sex rather than biological sex. However, the memorandum, in its discussion of gender identity, says that gender is used in this definition because it is different from sex. Gender is used in this definition rather than sex as it is a different concept, understood to be part of a person's social identity rather than biological characteristics. So, the explanatory memorandum on which the AHRC is relying to include men in the categories of both female sex and lesbians also defines the word sex as biological, and the definitions of sex and sexual orientation in the Act use the word sex, not gender. This point has not yet been argued at tribunal or court anywhere in Australia yet, and it has not been put to the government, including the Attorney-General Mark Dreyfus, who is the current Attorney-General and who was the person who gave this explanatory memorandum in Parliament in 2013. Both of these could be done. Quickly, under the Victorian law, the EOA defines gender identity roughly the same as the SDA, and like the SDA fails to define sex, it never has, and it's also never defined woman or man. The definition of sexual orientation is different from the SDA though. Despite being called sexual orientation, the definition is attraction to or relations with persons of a different gender or the same gender or more than one gender. Before 2021, it used to be a crazy definition, homosexuality, including lesbianism, bisexuality or heterosexuality, but that was just way too complicated. Arguments protecting biological sex that are available for the SDA therefore disappear for the EOA. We do not have them in Victoria. To avoid discrimination, the argument currently needs to be framed as biological women having a need that justifies the exclusion or differing treatment of non-biological women. There are lawful exceptions to discrimination, permanent exemptions for organisations such as membership-based clubs, and for activities such as hiring an intimate carer. And each law allows discrimination against a more privileged group if it's a measure aimed at achieving equality, read as substantive equality, for women against men, for instance. But these exceptions are themselves vulnerable to the way that attributes like sex are defined. Lee Hazel, for instance, from Detransitioners Australia, has MS. She wrote to the Commissioner for confirmation that her case fell into a permanent exception category because she wanted to hire a woman for intimate care. The Commissioner suggested she would be discriminating on the basis of gender identity and that this was therefore not covered by the permanent exemption for intimate care. This is the letter, and that's the relevant sentence. This exemption does not apply to discrimination on other prohibited grounds, including discrimination on the ground of gender identity. So, it's a practical conference. Strategy. Legal actions are limited in their ability to change the law through the courts. Gender identity has replaced sex in most legislation, and the courts cannot simply override Parliament because they think it's bad law. In order for a court to invalidate an Act of Parliament, they must find that the law is not lawful, that it was, for instance, outside the power of Parliament to make it. In the Hindmarsh Island Bridge case in 1997, the High Court was asked whether the Commonwealth could use its 1967 race power to pass Nazi-era laws against Indigenous people, in breach of majority values and multiple human rights treaties. The court said yes. General values on human rights and international treaties are not law in Australia. It is very hard to give the courts an argument that allows them to invalidate a law. So, what might be, therefore, the reasons for engaging with discrimination law? One reason is legal, testing the law and trying to change it. If a group challenges a determination by the Commission or invites a complaint against itself, it can test the interpretation and application of the law and argue that this should change. Commissions and tribunals are fact-finding bodies, not law-making bodies, but they can still be persuaded that their interpretation of the law or application to the facts is wrong. Another reason is political, to lobby lawmakers to change the law. This can be done directly, confronting members of Parliament with the dystopic outcomes of laws they are responsible for, or by motivating the public to agitate against lawmakers and giving people simple and clear instructions on what to do. The third reason is practical, to hold an event, to hire a worker. Women have real needs and want to know that this is not unlawful. Winning that piece of paper that says you do have a legal defence if some man in a dress comes and tells you he's a lesbian, complains to the Human Rights Commission that you've discriminated against his gender identity, this can give you the confidence to organise, to meet the real needs that we as women have. But you don't even need the piece of paper for this. You can just go ahead and hold your event, hire your female care worker, let the complaint come to you and then defend it. And either way, seeing women do these things can reduce the chilling effect and encourage more. And the more people who do it, the more we change the popular understanding of what the law is and put pressure on Parliament to endorse a behaviour that is common and accepted. You know, Sunday trading wasn't legal in Victoria until a hardware shop owner ignored it. And he never paid any of those hundreds of thousands of dollars worth of fines because the community protested against it. And so Parliament changed the law. But I understand why people want the piece of paper, because putting yourself out there and feeling like a rabbit on a greyhound track is scary. So, where to from here? Ultimately, there is a role to be played by genuine applications for exemptions and possible appeals when those fail. There is also a role to be played by genuine complaints filed against individuals or organisations who discriminate against women, lesbians and gay men in preference for gender identity, and then possible appeals when those fail. But not every matter will need to be pursued legally, or will have the strong facts or funding necessary to do it properly. And legal challenges will not work on their own. The law has been comprehensively changed by Parliament, and Parliament needs to be convinced to unchange it. So I would encourage any woman wanting to engage with discrimination law to engage the three axes of legal, political and practical, get legal advice beforehand rather than afterwards, and milk every case for as much leverage as it can get politically and socially, because each case is a lot of our time and money. Thank you.